Welcome. Good morning, everybody. Thank you so much for joining and being with us here today for the Sunday Law Bulletin. And a warm welcome to one and all. It's been a long time that we haven't had such a session, and we would be definitely awaiting this wonderful session today on the admissibility of electronic evidence. Before we go ahead with today's session and introduction of our expert speaker, let's give a brief introduction about Lawyers Development Forum. So, Lawyers Development Forum has established to foster development and promote interest in the legal field. Not only do we actively organize academic lecture series, which have been immensely beneficial for many young advocates, but we also arrange many sports activities, including cricket matches and badminton tournaments for the advocate fraternity. We also conduct conferences featuring esteemed High Court judges and expert speakers from the legal profession who provide valuable guidance and insights. And as we all know, we host the Sunday Law Bulletin every Sunday, where experts from various legal specializations share their knowledge and address key topics of importance. And for this endeavor, we are particularly grateful to Advocate Dr. Rajendra Anbhule, sir, President LDF, Advocate Vijay, Shelar, sir, Secretary LDF, Advocate Abhishek, Jagtap, sir, President LDF, for starting this. As we move ahead, let us walk through this program briefly. On today's Sunday Law Bulletin News and Views sessions, we'll be having the esteemed presence of a renowned figure, Advocate Pushkar Patil, sir. He will be addressing the topic Admissibility of Electronic Evidence, an epitome of brilliance, excellence, and perfection. We are eagerly awaiting his session. Before we go ahead, a brief introduction about our expert speaker. Pushkar Patil sir has completed his education from the prestigious ILS Law College, BSL LLB from the same college, LLM from University of Glasgow, Scotland, DCL from Bharati Vidyapit, and DHL from ILS Law College again. Not only he's an expert in the criminal field and family law related matters, he is also an exceptional cyber techno-legal pioneer awardee. He's also been a national cricketer. He's a vice president for the Vaco Kickboxing Pune. So he has appeared in more than several 150 times in the newspaper articles. But what makes his approach different is his wide variety of cases that he has handled. And today we'll be having his esteemed presence, who will be delivering us the important topic of admissibility of electronic evidence. Now, before wasting much time, we will just quickly invite sir. Sir, can you hear me? Pushkar Patil, sir, can you hear me?
Yeah, Ruchi ma'am, I can hear you.
Yes, fantastic. So let us go ahead, and I've handed over you the mic. I'll be turning off my video and I'll be sharing the presentation that you have shared. Let me know if it is.
Sure.
Yes.
Yes, please.
Yes. Great. All right. Over to you, sir.
Yeah. So first of all, thank you, Ruchi ma'am. Those were the wise words, and a warm welcome as always. And I thank LDF for having me here again. You said that I am an expert. Well, there are lot many seniors are appearing today for this lecture. So let me be very clear. I'm not an expert as yet. I am learning, and that is the whole purpose of practice. I believe that we learn with experience. And today's topic was basically shortlisted for the purpose of electronic evidence because most of the advocates are not aware how to go about presenting electronic evidence, and electronic evidence, be it in a documentary format or be it in the real evidence. I just want to clear out certain misconceptions amongst all the lawyers. And the reason being that most of the times what happens is I have appeared in cases where the matters have been there for evidence stage, and I come across the opposite advocates who are not able to present a case, not because of the experience or not because of anything, but because of the guidance. So today's lectures, definitely there are a lot of seniors appearing in today's lecture, so they might know better than me, but you can always opt for having their guidance as well. I am going to give you an introduction on the purpose of today's lecture, in order that you can find it easy to understand that if tomorrow you deal with a case and where you want to go and represent your case or submit an evidence, or the best, do the best for your client. I am trying to, through this medium, clarify certain misconceptions and make it simple and easy for you to understand. Now, today's lecture is about admissibility of electronic evidence. Evidence. What is evidence? So this is a big question that everybody wants to, understand. You deal with a case. Now, we have all learned in the law school that the burden of proof is on the person who alleges it. Now, this is not in form of a prosecution case or an accused case or any civil case. It is about proving a point. Now, can truth be the evidence itself? Now, that is for you to answer. Let's go to the second slide. I want to read out this quote. I must speak the truth and nothing but the truth. The reason why I have stated it over here is every person that appears before the court is under an oath. The evidence is recorded under an oath. It is presumed that whatever he is going to say is the truth. But is it? Now, you have represented your clients. You have tried to, we all are advocates, of course. We all have tried to manipulate certain facts, and we have tried to represent our case in our own terms. But is it the truth? Well, you have to take it from the perspective of the mythological references. For some, it might be mythological reference. For some, it might be the history. For some, it might be the godly, the mythological aspect. Understand this. Your version of story may be truth for you, but that version of story may not be the truth for another person. So there is a difference of version. Now, every time you go before the court and you are trying to represent a case, the opposite party will have another angle to look at it. Say, for an example, you are representing a family matter. Now, I'm making it very simple for you all to understand. Now, you are representing your client who is a husband in a family matter. And say, for an example, I am representing the wife. Now, what has happened? There has been a dispute between both of us, husband and wife, our clients. You go to the court and seek divorce, stating that I have been rude with you. Now, you are appearing for the husband. I am appearing for the wife. I am trying to tell to the court that whatever incidences that you are trying to tell are half story, because you cannot clap with one hand. So I am trying to represent my case on the fact that you are displaying one version, I want to display another version, and then my version is not a lie, your version is not a lie. But then, despite both being the truth, what is the evidence? Now, this is today's topic. Let us move to the next slide. Now, before we go into the aspect of evidence, I want to tell you a short story. Now, most of you must have read the Bible. Most of you have referred to the Bible. Now, this is a story from the Bible, and it is the tale of Susan, a story about Daniel, and it is regarding the story of Joachim, his wife Susanna, and the two corrupt judges. Most of you must be aware of this story. You all can definitely go and Google it. It's a beautiful story. And why I say beautiful is because the reason of cross-examination becomes important from this story. And there may be several stories, but I want to refer to this story. And every time I give a lecture on evidence, I refer to these stories because it makes it simple to understand. Now, this is a case where there was a small town. And in that small town, Joachim was the court officer. Now, his purpose was that he used to guide the two judges. Every time there is a dispute, minor disputes between, say, for example, there are farmers in that village. So they used to go to Joachim and in front of those two judges, and they used to say that, my lords, I was supposed to pay the A. So say, for example, there is a case of A and B. They are before this court of two judges, and there is Joachim, who is the court officer. So A would say that I had given a hand loan of rupees, say, for example, 500 to B. And B was supposed to give me this XYZ of farm yield, but he failed to do it. Now B requests that because there was no monsoon, because there was no proper rains, because there was dry area, I could not yield that much of farm yield, and I was not able to give it to A. So he is asking for leniency. Now, what Joachim used to do, Joachim, as a court officer, used to assist those two judges in saying that I believe that because of the weather conditions and the climatic conditions, B was not able to truly do anything regarding that agreement. So what we can do is we can give him another 1 year of opportunity. That is how the courts used to work. There used to be a court officer who used to assist the judges in understanding the reality. Now, everything. Now, if you go by the parameters of natural justice, you have to understand there can arise circumstances and problems which are need to be humanly treated. It cannot be said that just because A told me that I am giving you 500 rupees, you are supposed to give me the XYZ amount of the products. And if I fail to do so, then A has a case against me, right? That is the all purpose of the court. Why people approach the court? It was the duty upon the court to understand what is the factual condition. If B is not in position to give to A, how will he give? And at that time, in reaching the conclusion, these two judges used to refer to Joachim, that you guide us, let us understand what is the factual condition. Now, this was about the fair trial. What happened? One fine day, the two judges are changed, and all the proceeding used to happen in Joachim's house. So that is the history. You can go and read it. Now, two judges are appointed, newly appointed judges, absolutely corrupt. And this is in the history and this is in the Bible. So I am referring the Bible. So you have any objections regarding to that, I apologize. I do not want to hurt anybody's sentiments. So I am giving a disclaimer at the first. You can always go on the internet, read this story. Now, these two corrupt judges are introduced in that town, in front of whom Joachim is still the court officer and the proceedings are still taking place in Joachim's house. What happens one day? A and B come over there and A says that I have given 500 rupees to B and B was supposed to give me this farm yield. B comes with the story that because of the climatic condition and I was not able to give it. But what A has done, he has already approached the judges from the back door. He has told them, you fine him 1000 rupees, I'll give you 100 and you give me the 400. So this is how they, in short words, what we call as internal backdoor settings under the table. So people started doing that, and the fair trial somewhere lost its purpose. Even Joachim was not heard, and all this corruption started happening from those two judges. Now, one fine day, these two judges saw Joachim's wife Susanna, and they had ill intentions about her. Susanna used to go in a garden and for getting ready for her bath. These two people the two judges I'm talking about, two judges used to follow her, watch her take a bath, and they had ill intentions about her. And they wanted to establish physical relations with Susanna. Now, what happened one day? Susanna found out that these two corrupt judges are watching her bath naked. And they also confront her. They offer her that they want to keep physical relations with Susanna. Susanna refuses. Now this becomes an ego war for these two corrupt judges. And what they say, that if Susanna goes to Joachim and Joachim goes out in the public, they will expose these two judges. So what these two judges do, they start spreading in the town and they call upon the servants and they tell, Susanna was having an adulterous relationship with a random person in the garden. And this is an offense of adultery, and for which purpose Susanna should be stoned. Now, in those days, the punishment for adultery was death by stoning. So now two judges have told out in the public and to the servants that Susanna has committed adultery and she should be punished. Everybody believed it because it is the word of the mouth of a judge. There is no question of, countering it. So everybody believes it. Everybody starts believing Susanna. Everybody starts judging Susanna. And ultimately, the two judges who state that she is in an adulterous relationship, they pass a judgment that Susanna should be stoned to death. Now understand this. All this is happening because why? Because she refused to have physical relationship with those two corrupt judges. And what they do is, in order to take their revenge or in order to show their ego war, they punish Susanna in their own court. Now, Susanna is being taken away for stoning. Susanna confronts Joachim. Joachim says that, Susanna, I know, I believe you, but the judgment has been passed. So while they are on the way, there is one character in the Bible by the name of Daniel. And you all can read, he was so believed that in the God-man, the first of the God, the person sent by the God. Daniel stops that rally. And everybody is shouting everybody is excited. They are trying to celebrate it as a ceremony that some person is going to be killed. But Daniel comes over there and Daniel says that, no, I want to give an opportunity to the accused, that is Susanna, to tell her version of the story. And then what happens is Susanna tells her version of the story. So Daniel decides that both these two corrupt judges should be confronted. So what they do, they take one judge in one room, the second judge in second room. They ask the first judge, when Susanna was bathing and having her so-called adulterous relationship, where was she bathing? The first judge says that it may be some yellow color tree. B is asked, when you saw Susanna, under which tree she was having the relationship with that another person? And he says, under the banyan tree. Now banyan tree is green and the first judge is saying yellow, there is a contradiction. And based upon this version, they came to know that all these two versions represented by the two corrupt judges do not corroborate with each other. And based upon this, Susanna was acquitted. Those two judges were held accountable and they were punished. Now, this is the importance of cross-examination. Just because a judge gives a version, that is not final. Now, of course, if the Supreme Court gives now, you can always go into review, and even review is dismissed, then God bless you. But then ultimately, the purpose is, just because a word comes from the mouth of a judge does not mean that is truth. And every accused has the right to defend himself. Every accused has the right of cross-examination. And this is the importance of cross-examination. Now, I hope you have understood the story. You can always go and read in depth. It is a beautiful story. Next slide. Now, understanding the electronic evidence. Now, electronic evidence is basically a form of a document. It is, at the end of the day, it is a document. You want to produce something, you want to produce WhatsApp chats, you want to give call record details, you want to give anything. It is ultimately, at the end of the day, it is a part of a information technology. Now, why it becomes important to understand what is information technology is because every data that you want to show to the court is somehow, somewhere related to the internet. And why I say that it is related to internet, because let us understand through examples. You are on call with somebody, and that some person is recording the calls. In one way or another, if I am talking to you on a call, there is an internet connection. And that connection or that data that we are exchanging between ourselves is called that whatever conversation that we are having is the data. Now, what is the purpose of this information technology? The purpose is to store data, to receive data. As I said, let us understand it from the example of a call. Now, I give you a call, you are receiving the data, I am sending you the data. Now, if I start the recording, I am storing the data. Now, I want to keep that call recording in some pen drive or my computer or laptop or my Gmail. I am transferring that data. At the end of the day, it is the data that becomes the electronic document. Now, say, for example, if there is a call recording between you and me, and on the call, I provoke you. I shout on you, I provoke you, and in return, you counter-provoke me by abusing me. I will cut the recording where I have provoked you. That becomes manipulation. Now, I believe you will understand a document, electronic record can be manipulated. So I'm not on the aspect that electronic evidence cannot be tampered with. It can be easily tampered with. But then this is data, and electronic data has to be carefully handled. Now, what are the primary modes for this introduction of the data? Telephone, laptop, computer. Now, these are all the primary sources, a TV, a tablet, anything that you're using, it becomes a primary source. But what is the secondary mode? The secondary mode is how that internet is connected or how that communication data is connected. And that is through the Wi-Fi router, through the software that you are using, through the software that is in your phone, then the website, then the e-commerce or any shopping app you're using, or any kind of an application, or the artificial intelligence, anything that in your primary device, as in your physical device, is connected to is the secondary mode. So I believe the only purpose to make you understand through the information technology is to make you realize that data is only what we are talking about today. Next. Now, this is only a brief background about the Information Technology Act. The only important thing about this is highlighted in the red color. The Information Technology Act was introduced for the purpose of making the electronic records authorized. And what is the electronic record or the electronic signatures? Because earlier, prior to the introduction of this act, anything that was in digital form could not be proved before the court merely because there was no provision in the Indian Evidence Act, or there was no such law for the purpose of Information Technology Act where we can convince the court that this is a data, this is an electronic document, and we require to prove it. There was no provision whatsoever. So by introduction of Information Technology Act, as per Section 3 and Section 4, electronic records and electronic signatures are recognized in the court of law. This is the first step for recognition of electronic evidence. Next slide. Now, in brief, these are the some of the cases. Now, this list is not exhaustive at all. There can be several other cases. Now, these are a brief cases where electronic evidence becomes extremely necessary to be stored. The first is cyberbullying, cyber stalking, cyber crime. Everybody must have in their life sense that if you are operating a Facebook or say, for example, Instagram, you receive these messages, DMs, what we call, or the comments that are either provoking in nature, abusive in nature. They are threatening. Somebody is DMing you some cheap substances. Even the woman in this today's lecture can relate. There are people who try to approach you when you are not willing to do so. So those type of messages, it's called cybercrime. It falls in the category of cybercrime. It is cyber stalking. It is cyberbullying. Now, there are children who are using the online gaming apps where they are abused by the opponent. This all falls in the category of cyber crimes. So if somebody has abused you, that abusive word, how you protect it and how you produce before the court, that is where the electronic evidence becomes necessary. The second is cyber terrorism, pornography. Now, this is all conceptual. You can simply go through the entire slide. You can realize that all these matters are where the electronic evidence becomes extremely necessary to be stored. The important one is at the extreme last, which is the civil, criminal, and matrimonial dispute. Now, which we are talking about in terms of representing, or say, for example, submission of electronic evidence. So these are the cases: civil cases, criminal cases, matrimonial disputes. Matrimonial disputes in today's world have become the PowerPoint where everybody requires to submit some or other corroborating substances with their version. Therefore, in today's lecture, we will be discussing with the examples of civil, criminal, and matrimonial disputes for your better understanding. And these are predominantly the important sectors where, electronic evidence has in today's world become extremely necessary. For example, civil. For example, if there are two companies who are dealing with each other on contractual basis and they sign an e-agreement, this e-agreement is basically through their accounts, through their emails. Now, if tomorrow one party goes into the court and they want to prove that there was an existing contract between A company and B company, where is the proof? That proof is the agreement. And say, for example, the other party says that this agreement is online, we never signed it. At that point of time, that agreement, e-agreement, becomes necessary to be proved before the court. And how would you prove it? Now, let's see how you prove it. Now, in criminal case, second, if the police are investigating a matter, and as per the new provisions of the BNSS, the police can start video recording of any of the incidences they want to do the Panchanama of. Now they are recording that Panchanama, they are recording everything in their devices. These devices may not be in front of the court, but the data stored in those primary devices, how do you prove it? And the third, matrimonial dispute. Now let us go back to the same example. There is a dispute between husband and wife. Wife has alleged that the husband beat her and the wife has the recording of the same. Now that recording is the data and she has recorded that something in her primary device. How do you prove it? Now this is the purpose of how to represent or how to produce electronic evidence. Next slide, please. Now let us understand what are the types of evidence. Now these are the terms. Now basically it is only for your understanding. I'm going to very briefly explain to you what are these terms. The senior advocates already present in the lecture are already aware about. So I need not, I'm not trying to challenge your brilliance in the industry. I'm only trying to give it a brief idea to how to understand. Oral evidence is something that it is stated by the person in court, whether it is not supported or may be supported by any corroborative document. Now, oral evidence is per person says, let us understand everything from an example point of view. A murders B. C has seen A murder B. B comes to the court and B says, yes, I have seen A murder B. This is a oral evidence. And this is a direct evidence as well, because he has himself seen. Now, there is a person D who comes to the court and says, C told me that A has committed murder on B. Now the version of D is hearsay evidence because he was told by C. He has not himself seen it. Now this is form of oral evidence. Anything deposed before the court is oral evidence. Second, documentary evidence or presumptive evidence. Now understand this. Documentary evidence is something, say for an example, if there is an agreement between two persons. Now, physical copy, we are not on the talks of electronic evidence. Now, there is an agreement copy, and this agreement is signed by both both the persons. Another person, A and B, have not refused the signature on that document. This is a documentary evidence. It is as simple as you can understand. Now, if there is a dispute between a tenant and a lessee, now both these persons, the lessor and lessee, both these persons are technically bound by that agreement. That agreement is documentary evidence. So anything that is noted down on a paper is documentary evidence. Now, presumptive evidence. Say for example, what is a presumptive evidence? A has committed murder of B. C goes to the police station and files the complaint that somebody has committed murder of B. It is a presumption. Now it is presumed. Now it is admitted that B has been murdered. This is presumptive evidence. Is it a case where we are challenging that B has not died? It is not a case. So B has died. So that is a presumption. B has died. A murder has been committed. That is presumptive evidence. Now primary evidence. Primary evidence. Now let us go back to the first example where C has seen A commit murder of B. That is, he has himself seen it. That is the oral evidence. A says to the court that when I saw A commit murder, I was the one who went to the police station and I filed the FIR and I recorded my statement. He has given the statement, oral evidence. If he says that I have also recorded that something in my mobile phone, and if he gives that mobile phone to the police, primary evidence. But if he says, I have recorded the photo in my mobile phone, but now my phone has become corrupt, but that photograph of A committing murder of B, I have sent it on my account and I have taken out a print and I am producing before the court or before the police. That is the secondary evidence. Now, whether secondary evidence is admissible or not, it will depend on case to case, because in absence of a primary device, secondary evidence cannot be permitted. Now, primary evidence, the basic example of primary evidence you can understand from this case, if there is an agreement between A and B produces that document before the court, the original document, which is signed, which has the seal and everything is original, that is the primary evidence. But if he files the true copy, or say, for example, the Xerox copy, that is the secondary evidence. Secondary evidence can become admissible if the source of primary evidence is either not in dispute or it is proved before the court. You cannot go to the court on the basis of a Xerox copy and say that this is a secondary evidence, you should exhibit it, and this is the final proof. Now that becomes a weak form of evidence because the primary document is not before the court. So understand this, secondary evidence holds extremely low amount of value and it will depend upon case to case. So be sure that you cannot directly rely upon secondary evidence. Real evidence is basically, now again back to first equation. C has seen A commit murder of B. That is the real evidence. Now he has seen the actual murder. That is the real evidence. If D comes and says, C has seen A commit murder of B and C told me, hearsay evidence. It will have no value in the eyes of law. Hearsay evidence, I have already explained. Now electronic evidence. Now say for an example, the same example. C has taken a video recording of A committing murder of B in his primary device. That recording is the data, and he has the device, and if he submits that device or he submits that video, both are electronic evidence. Now electronic evidence, how to prove electronic evidence, we'll look in the next slide, but ultimately understand this: anything given in digital form is electronic evidence. Simple, better understanding. Anything that can be seen on tablet, in any of the primary devices which we discussed earlier, electronic evidence. Corroborative evidence. Now A says that C says that I have seen A commit murder of B. C has seen it. C is the real evidence. But what if C says that I have seen A commit murder of B, and there is an expert opinion which comes and says that the knife used in the offense may be capable of murdering a person? The version of the expert becomes corroborative. That yes, the version of C, who has seen A commit murder of B with a knife, and that knife has been testified by an expert who says that a murder can be committed, that version is corroborative evidence. Then what is the best evidence? The best evidence is a evidence which is seen by C in the first case, where he has himself seen it. Circumstantial evidence. Now here is a twist. Let us twist the example. A commits murder of B. C does not see that committing murder of B, but C has seen A run away with bloodstains on his shirt and a knife in his hand. This is a circumstantial evidence because murder has taken place, but it is not clear who has committed the murder, but it can be presumed. Now, once again, we go back here, presumptive evidence that since A was running, the subsequent conduct of A running away from the scene, which the C has seen, is itself sufficient to show that there were circumstances. You must have committed the murder, you were running away. The version of C in this scenario is circumstantial evidence. Now, derivative piece of evidence. The derivative evidence is, I guess there are several hands which are raising. We are going to answer the question and answer at the end. So I believe that the chain of the theme should not break down. Yeah, so derivative evidence, if everybody is following the Supreme Court of India in recent case law of marital disputes between husband and wife, court has stated the call recordings or the if the husband is spying upon the wife or the wife is spying upon the husband, the electronic data or anything that has been recorded, although it violates the personal liberty of another person, that evidence can be used in the proceedings, which will be termed as a derivative evidence. As in the meaning is derivative, that something which is not legally permissible was used for the purpose of proving a point which becomes evidence. This is derivative evidence. Direct evidence, first case where the person has directly seen it. Supportive evidence is now once again it is similar to the circumstantial evidence, where it can be said that I have not seen A murder B, but I have seen him running away from the spot with bloodstains on his mind. So that is a supporting evidence to the prosecution version. And dying declaration at the end, where it is presumed in the Indian law or in the common law countries that any person who is on the deathbed would not lie. So this becomes admissible. Of course, there are protocols where you have to have the signature of the doctor. You have to have two independent witnesses. The version should be of such quality and nature that can be believed into. So dying declaration is a form of evidence. So these are the basic terms, and why I have explained to you is in order to understand that directly jumping to the electronic evidence is not going to give a clarity to you about what exact evidence we are trying to deal about. Next slide. Now, these are some of the important sections of the Bharatiya Saksha Adhiniyam, which replaces the Indian Evidence Act. Now, these are basically only for your purpose of understanding. The 56 deals with the proof and contents of documents, 57 is primary evidence, 58 is secondary evidence, 59 is proof of documents by primary evidence, 60 in cases in which secondary evidence relating to documents may be given, 61 electronic or digital record. Now understand this electronic and digital record is as per the Information Technology Act section 3 and 4, which gives it a validity. Then section 62, special provisions as to evidence relating to electronic record, admissibility of electronic records. Now understand this. I want to explain to you 51. Fact judicially noticeable need not be proved, and facts admitted need not be proved. The basic understanding of evidence is that if, say for an example, there is a dispute between an husband and wife before the court, most of you must have seen at the very beginning, while filing a petition for divorce or for restitution, we adduced the list of document in which we adduced the marriage certificate or the invitation card. And if the opposite party comes and admits that, yes, this is a list of document, then this is the marriage invitation, that fact is admitted. So subsequently, when the evidence opens up, the wife does not have to come and prove that A is my husband. You see, because it is an admitted fact. You need not prove. Something which is admitted, you need not go into the depth and prove it. And second, fact judicially noticeable need not be proved. Now, what is the fact judicially noticeable? Now, what is the basic understanding is that if, say for an example, there is a case where A says, go to the first example. C says that A has committed B's murder under the Z bridge. Now, if this is a case, now everybody is aware. I believe there is a place called Z bridge in Pune. Does the prosecution need to prove that there exists a Z bridge? No, because that is a fact judicially noticeable. Yes, there is a place called Z bridge. It exists, and the does not necessarily need the prosecution to prove that Z bridge exists. So if we go into word by word of proving something, then that trial is going to be endless. That will be, it will go back to the existence where there exists a city called Pune. So facts judicially noticeable need not be proved. Now, if once we have understood these two parameters, the subsequent events becomes easy to understand. There is a Z bridge. The court knows there is a place called Z bridge. Now, unless the Z bridge has been demolished and at the time of incidence, there was no place called as Z bridge, then that becomes something which you have to prove. But then for time being in force, facts judicially noticeable need not be proved before the court. But then other responsibilities, other burden is on the person who alleges it. Now, this is an exception with all the advocates relating would relate to it. Under section 114A of the Indian Evidence Act, which is the older one, if a woman who is a victim of sexual harassment, if she goes to the police and gives a version that A has sexually harassed me, A has troubled me, A has caused assault on my dignity or modesty, that will be considered as the truth. Now, that whether that is a gospel truth or not, that will be decided in the trial, but that can be presumed that yes, such thing has happened. And why that law is made, now I am not the lawmaker for that. Maybe it is because of the patriarchal approach that our Indian society has gone into, but it is believed that when a woman files a complaint of sexual harassment, it is deemed to be true and the burden immediately shifts on the person who has been accused of it. Next slide. Now, section 63 of Bharatiya Saksha Adhiniyam. Now, we are coming to the admissibility concerns. Understand the primary evidence in form of examples. Say, for an example, there is a dispute between husband and wife, and making it very simple for you to understand. Wife calls the husband. Husband is recording that call, and wife says, because of your repeated harassment to me, one day I will commit suicide and I will implicate you and all your family members. Now, this is a threat given by the wife. Whether she would do or not do, there are ample of case laws which state that when a spouse threatens of committing suicide, that amounts to cruelty on another spouse. So now the husband has recorded that call in his mobile phone. This mobile phone becomes the primary evidence. If he wants to prove his case, there is a recording in this mobile phone. What the husband has to do, the husband has to submit this mobile phone in the court, and the husband has to give an application that this recording in this phone should be played. This is primary evidence, making it extremely simple for you. Your device is the primary evidence. The recording in it is in it, and it is there forever, as in from the moment it has been recorded. Second thing. Now, for the purpose, I am using this mobile phone, but I want to use this mobile phone and I also want to give the evidence. So on the initiation of the very first day, I am not in a position to submit my original mobile phone because everything is connected to that. My daily life is working on this mobile phone. So what do? I take that recording out on a pen drive or a CD, and I submit that CD in the court along with a certificate of section 63 of Bharatiya Saksha Adhiniyam. Secondary evidence, but along with the certificate. Now, what is the importance of electronic record? Simple. My entire case, the example that I gave you regarding the family matter, my entire case relies on that. Now, why it becomes important? Say, for an example, if I say to you that there is a case of, let us go back to the murder case. A commits murder of B. C does not see that murder, but C saw A running from the spot with a knife in his hand and blood on his clothes, and C has recorded that video. If C submits that video, that is a circumstantial evidence that somebody committed the murder, but then why were you running and why is there blood? It is a presumptive evidence that you committed the murder, and this video recording produced on the record is sufficient to show that you have something to do with it. But A commits murder of B, say for example, nobody has seen it. C saw A running, but there is no knife in the hands, no clothes, no blood stains on the clothes of A, but A is merely running. Then if C submits that video recording that, see, I have seen him, and although there is no blood mark, there is no weapon, nothing, but possibility is that A committed the murder. Still, corroborative evidence that why were you running? Maybe you have thrown the weapon over there only. Maybe no blood stains are there on your body. Simple. Third example, nobody seen A has committed murder of B. Nobody has seen. After 4 or 5 days, C has seen A on the spot where the murder was committed, and he records that shooting. A has no weapon, A has nothing on his hand, and this incident is after 4 to 5 days. And C is producing the recording in the police station or the court by saying that 4 days ago there was a murder on this space, and what is A doing here? Is it important? Is it important? As in, what are you trying to reach upon? What conclusion are you trying to reach upon? There is no conclusion prima facie. Unless, of course, the circumstances are to show that A is trying to see whether he has left any evidence or not. That is a different story. But in present form of circumstances, is that video relevant? Is that video disclosing the murder? Is that video disclosing that A is running away? Is that video supporting any kind of a circumstantial evidence? It is not. So it is not important. So importance of electronic records has to be in consonance of a point that you want to prove. You cannot come to the court and say that I have a matrimonial dispute with my wife and there are calls between us. I have not recorded anything, but this is my mobile phone I want to submit. And do what? Do what? You want the court to see that you own an iPhone? That is not part of the evidence. Next slide. Yeah, we are going to answer all the question and answer sessions at the end of the session, please. Next slide, Ruchi ma'am. Yeah. Now, what are the conditions of producing this electronic evidence? First of all, the above slide. Yeah. Now, what are the conditions? The first condition is that the electronic evidence, the electronic record. Ruchi ma'am, down 10 number slide. Yeah, this one. Yeah, the electronic device in which the record has been stored is operated regularly over a brief period of time by the person using it. Now, if I am recording that video call between the husband and wife, and I am the husband, I'm recording the call of the wife, there the document, the audio recording that is recorded in this mobile phone, this device has to be regularly in use. I cannot say that only for the purpose of recording the call, I have bought a new phone. If that is your contention, then that means even if that document becomes admissible, it is a derivative piece of evidence that you wanted to plant something. But this electronic evidence has been my ownership. I am using it. Now this has to come in your certificate that the electronic evidence that you want to prove to the court, this electronic device is owned by you, has been regularly used by you. It does not have any kind of battery problem. It does not have any kind of a major problem, major electronic problem. It can run smoothly. If there are some glitches, those glitches are negligible. Now this device and all the recording audio, everything is accurate. This is everything that you have to produce in your 63 certificate. Now, you have to prove to the court that now eventually if you submit this mobile phone in the court and the phone battery dies, you have to mention that the battery, the electronic device that I have produced on the record can be charged through a charger. It has a special charger. That charger you have to submit in the court along with this device, and you can charge, open the proof, show to the court, this is your primary device. But what happens with the 63 certificate? Now you don't want to give the phone, but you have to submit that the data that I have submitted to the court is recorded in this phone. This phone has to be charged with this charger. I have both the primary and secondary proofs available with me. I am submitting this recording on before the court on a CD. This CD is prepared by me on my HP laptop. My HP laptop is also comfortably working. It does not have any problem. It is accurate. Now, after that CD was burned, I took out that CD, I put it in a paper, I am submitting before the court. I have taken 2 copies of the CD or 3 copies of the CD. One I am submitting to the court, second copy I am giving to the respondent. This is how that certificate should have. This certificate should have the mode of how you have created the CD, how you transfer the data from primary device to secondary device. That chain should be there. Now, if you come before the court and you give a CD with audio recording and you submit that this CD has a recording taken from my phone and I am submitting it to the court, and if you give such certificate, then my friends, may God bless you if the opposite advocate accepts that certificate. But if I am supposed to conduct the cross examination, the first question I'm going to ask you, you have not stated the device from which the data was transferred to the CD. Have you adduced the bill of that primary device? Have you adduced the proof of ownership of the primary device? Have you adduced the purchase receipt of the CD? Have you adduced the details of the computer on which you burned the CD? Have you adduced the hash value of the CD? Have you adduced any document showing how you took the primary evidence into secondary evidence? God bless you. I'm going to grill you, and that is going to be a history that you should not be willing to repeat. So your certificate, there is no straitjacket formula or straitjacket format of the 63 certificate, but it should contain your name. It should contain the details of the primary device. It should contain who owns the primary device. It should contain the primary device is absolutely in working condition. It should contain that the recording that you have done in the primary device, at what time you recorded, how long is the recording, who is conversing, at what point of time that threat is given. This specification comes, and that is called the transcript. So section 63 has to be supported by a transcript of whatever proof you want to give to the court. Now, then subsequently, this primary device, you connected that primary device through a USB cable to your laptop or some laptop from the as in the cafeteria. You went over there, you connected the USB at XYZ time, you copied the data from primary device to secondary device. That data was stored on the cafeteria laptop or your own laptop. From that laptop, you inserted a CD. That CD was purchased by you on dash date. On that CD, you copied the data. That data, after it was burned on the CD, you removed the CD, made 2 copies of it, and now you have submitted to the court. You are willing to produce the primary evidence. Primary evidence is your mobile phone. You are ready to produce your laptop if the court calls for, and whatever you have stated above is true. Now it is in a form of a certificate, so it need not be in a form of an affidavit, but the contents are to be verified. Now this is how the details should be. And if you go by the previous act of section 65b subsection 4, the format in which the 65b certificate has to be submitted is described in detail in that case. So these are the conditions for electronic record. If you are under the impression that you have recorded something, you have taken it in a pen drive, and you submit the pen drive to the court, and you give a 63 certificate stating that whatever it was in my phone, I have submitted in the pen drive, and this should be admitted, it won't. Now, if the judge is pretty sharp, smart, he is not going to exhibit the document. You want to prove that document, you support it with a proper 63 certificate with all the contents that I have just told you. Next. Now, these are the important case laws that you have to understand. Now, we will briefly discuss it. The first is Anwar P versus PK Bashir. In this court, the Supreme Court has stated that any secondary evidence which comes to be produced before the court has to be supported by a 63 certificate. 65B, it was in the, as per the old Evidence Act. As per the new 63 BSA certificate, it is compulsory. It is not discretionary power. You have to give it. You cannot come to the court and say, I have a recording and 10 years ago I got this, he threatened me, and now I want to produce to the court, but I don't have that mobile phone. Sorry, that will not be admissible, because the contents of 63, which I have already told you, has to be there in 63 certificate. And if you lie in that certificate that, yes, I can produce the device, and if God forbidden the court says that where is the primary device, produce it, then God save you, may God save you. That then I again have to take you back to the first quote where I have stated that truth and only truth is going to be relevant to me. The second case law is Shafi Mohammed versus State of Himachal Pradesh. Now, in this also, the Supreme Court has dealt with this case. Surprisingly, a contradictory judgment came before the court where the court stated not necessary that each and every case the Section 65B or Section 63 certificate is necessary. Contradictory judgment, because Bashir's judgment in 2014 stated that every electronic document has to have the 65B certificate. Then Shafi Mohammed case says not all the electronic documents require the 65B certificate. But once again, in the third case, Arjun Panditrao Khudkar versus Kailas Kushanrao Khudkar, the judgment of Shafi Mohammed has been overruled. Once again, it has become compulsory, mandatory, and not discretionary that every electronic document you want to produce before the court, every secondary electronic document you want to produce before the court has to have a mandatory co-assisting certificate under Section 65B or Section 63 of the BSA. So understand these three case laws from the perspective of the developments. So, and you can go and read all the three case laws. Arjun Panditrao Khudkar being the latest one of it. It is incumbent, it is compulsory, it is binding on all the advocates representing their clients that once the client is trying to produce an electronic document on record, assist it, submit it along with a 63 certificate. Next slide. Now understand these terms. Now these terms may sound a bit technical to you, but these become very important. There is something called as the hash value and the hexadecimal code. A hexadecimal code is basically a 16-digit generated number. Now it multiplies. It can be 16, it can be 32, it can be 64, it can be 256. So it is in the multiplication of 16 only. And what are these hexadecimal codes? Hexadecimal codes are basically A to F, A, B, C, D, E, F. These are the 6. And 0 to 9, that is 0, 1, 2, 3, 4, 5, 6, 7, 8, 9. These are the 16 digits, which is a hexadecimal code. Now, every time I have given here example 0 EAB. Now, this is basically a hash value code. I will explain to you what is an hash value, but understand a hexadecimal code. Now, this can either be 32 bits or 256 bits. Now, what is these bits? That is the alphabets, 0, E, that code. That 32 worded code or the 256 alphabetical code is called the hexadecimal code. Now, what is a hash value? Whenever you are trying to take out a hash value of an electronic evidence, so an electronic document, you put it on a website, you generate the hash value. That hash value of that photograph stays the fingerprint of that photo. How? Next slide. Ruchi ma'am, let us immediately move to the next slide. Yeah, next slide. Page number, let us go back to page number 14 and 15. Yeah, these are the websites. You can see the website. It is MD5 file. So over here, you can see the word drop files here or select. So once you click on this, and you attach an image or you attach a call recording or you attach any electronic document, it will generate a unique code, and that code will be attached to that file. And once that code, that fingerprint, it attached to that file, any slight change in that image will change the hash value. It will change the fingerprint. Next slide, Ruchi ma'am. So this is another site for you can generate the hash value. You can see multiple sites. You can see over here at the down there is SHA, SH224, SH256. All these are websites. All these are modes of calculating the hash value. And this you can do online also. This is free of cost. There are websites that provide it to you free of cost. Basically, the hash value, if you say, for example, if you take out the hash value from the MD5 site, your image or that electronic document that you are trying to prove before the court, if you go on this website and you put that photograph, that hash value is going to come off that image. So once you have put something and it will generate a unique hexadecimal code value, that is your fingerprint. So you can go, I have tried it. It is a brilliant software. But if you change the image even by a slight bit, the hash value will change on that website. Next slide, Ruchi ma'am. Let's give them the example. You can see the first image of a tiger. A tiger is sitting and the hash value has come 897AEFF. You see the hash value? Yeah. On the next slide, that image is cropped. Nothing else done. That image is only cropped, but the hash value has changed. In the third slide, now we have further cropped the image. The hash value has changed. But if I put the first image in that website, this hash value will come. If I put the second image in that website, the second hash value will come. This is basically the same photograph, but merely because the image is cropped, the hash value has changed. Understood? This is how the hash value apps work. Next slide, Ruchi ma'am. One more. Now, what is this file losing authenticity upon transfer? Now, if I calculate the hash value of the first image, it is 100% accurate. Hash value is 100% accurate. But now, I cannot produce this copy before the code. So what I do is I transfer this copy on my Gmail account. And from my Gmail account, I take the print. Now the authenticity is 60%. The originality is lost. So when you cross-examine, now how you cross-examine on this aspect is your own freedom. But you can always ask whether this image was taken in this phone or this image was transferred through WhatsApp to another person and he has taken the print, because then the authenticity is lost. And how that authenticity can be seen? The original image is, say for example, 1 MB. The second image is 500 KB. That means it is not authentic. That is the point. And if, say for example, you put a photograph on WhatsApp, some person from that WhatsApp forwards the image to some third person. The third person takes out the print. The authenticity is the third image. Original document lost. It's lost. The original authenticity is lost. Now, how do you do this? Now, you have to understand how to calculate the originality. Now, Ruchi ma'am, let us go back to the slide number 13. One more slide. Yeah, this one. Now, you want to calculate the hash value. The best way is to take the image from your mobile phone to your laptop, open the site of the hash value. Free hash value sites there are several multiple slides. Go over there, install the write blocker. Now, what is this write blocker app? Write blocker app is when you try to calculate the hash value, it will not reduce the authenticity of that image. It will not reduce the authenticity of that electronic document. Once you have installed the write blocker, you can install the write blocker on your Google Chrome also. Once you have installed it, enable it. Once you enable it, then put your file in the hash value, generate the hash value, save that hash value, which is the digital signature, along with that image, and that is your authentic image which was there on your mobile phone. If you do not use the write blocker, or say for an example, in cases of police machinery, where police have produced some photographs, or say for example of the spot or of the murdered victim, if they have not used the hash value, then already the secondary evidence is in question. But if they have used the hash value, if they have used the 63 certificate, then you can ask them whether they have used the write blocker app, because you have to mention the details of the write blocker app and on which website they use the hash value. Can you go back to that website, put the same photograph, and the same hash value can be generated? It won't, because write blocker, if not used, the hash value is going to change. Once again, the authenticity is going to be lost, and this is why it becomes necessary that the hash value and the write blocker apps, you should have the knowledge. Now, in matrimonial disputes, you can bypass this procedure because there is no strict provision of a strict cross-examination or strict evidence. Of course, the Family Courts Act come into picture, but then in cases of criminal investigations, this becomes a useful tool. Next slide. Next slide, Ruchi ma'am. Now, in cases where you cannot produce the mobile phone, as in, say, for example, we are talking only about mobile phone, but you have to think that if there is an incidence where there is a CCTV, say, for example, something wrong goes in court, and court has the CCTV. Now, this CCTV stores the entire CCTV footages and that device or that where that electronic data is stored, it is of such a nature so huge that the primary document cannot be produced to the court. In such circumstances, what is to be done? In such circumstances, you can always take the data from that entire device, only that limited data, and then follow the procedure of hash value and write blocker. Ruchi ma'am, the slide above, not this one, the slide above 15 number. I want to talk about that hash value.
Is still this correct? No,
14.
Okay.
Yeah, one more slide up, 13. Yeah, this one.
Okay.
Yeah. Now I have already told you what exactly is the hash value. I have already explained to you what is the write blocker. Now let us understand what is the hash busting applications. Now, if I have created a hash value of an image and I have submitted in court, and you are trying to cross-examine, for your preparations, you can always go on that website of which the hash value is given, and you can recheck whether the hash value is same. You know, most of the time, some opposite lawyers may try to play fool with you that he has taken the hash value. It may be authentic. I try to do that. In some of the criminal investigations, the police have adduced the MID file of hash value. For my own understanding, I have copied the data from the CD and I have put it on the same website to check whether the hash value is same. And how do I do it? By using the hash busting application of that same website. There is an option. You can check, decode the hash value, put that document which is submitted by your opposite party and check whether the hash value matches. And if it doesn't, then that is benefit to you. Now, transcript, as I said, that if there is an audio recording, along with the 63 certificate, you have to give a transcript. And how that transcript should be, you have to say, what if your my name is Pushkar, and say, for example, I have a recording with Ruchi ma'am. So I have to say Pushkar responded by Ruchi, and what is their communication. Now, why we are giving this communication? Because if tomorrow either of the party goes into an appeal, or say, for example, the same court wants to pass a judgment, that transcript should be easily available in front of it. And most of you must have realized, people, advocates practicing in family court, it is usually referred to a court counselor. So that is one of the mode of submitting the transcript to them. And this transcript is also exhibited. So it becomes an important document. You can always challenge the transcript. You can always say that the word used in paragraph number 3 was never stated. It is misinterpreted. So that objections can be taken in cross-examinations. Now you are the boss of your own cross-examination. So I would not be talking on that. Now, one concept is imaging. Now, what is imaging? I have been using a hard disk. Now my hard disk is valuable. Now my hard disk is, say, for example, 30,000-40,000 rupees hard disk. I cannot submit that hard disk in the code because I am using it. So what I will do, I'll bring another hard disk of the same company. I will keep it along with my first hard disk. I will connect both the devices to the computer. I will install the write blocker. Once I have installed the write blocker, I will copy the entire data from my first hard disk to second hard disk, which I have newly purchased. This process is called the imaging. And it can only be called as imaging if I have used the write blocker. Now I have created another hard disk. I will submit this hard disk in the court, and I will submit with a 63 certificate stating that this is a primary device with secondary evidence along with the 63 certificate by way of using write blocker imaging. Now this, nobody has used it. I have not come across any of the cases whatsoever till today where such a procedure has been used. So you need not be worried. You do not have to go into the stress. Oh my God, the Indian Evidence Act has gone so ahead that I do not know what to do. So you don't have to panic. You should be aware that there are remedies, and based upon which you can conduct your cross-examination. Most of the times, even the judges are not aware about it. In one of the cases where we were dealing about the fake currency printing notes, I had asked this question to the investigating officer whether you had used the option of write blocker and imaging. Thankfully, it was Honorable Murray Court who was pretty well aware about the imaging and write blocker. The police investigating officer was not. So that suggestion was put. You did not use the right blocker and the hash value applications. He accepted, yes, we were not aware about it, and the same was recorded. It becomes a useful tool, but then most of the times it might be a case that the judges would also not be aware. So you have to make sure that you explain to the judge, because that is your role as an advocate. Now, let us go to the next slide. One question is asked. We will be definitely answering it to you in 10 minutes. Page number 18, I have already given a short format of how exactly that certificate should contain. Now, this is based upon the judgments, which I have already referred to. All these procedures, this is basically a suggestion. There is no straight jacket formula of how you can draft a Section 63 certificate or Section 65B certificate. You can use this contents, because this gives everything that is essential. This list is not exhaustive. Understand this. Tomorrow, if you submit everything from this and the court questions to you why this is not included, do not blame me. I'm only here to give you an assistance. I'm not here to give you a foolproof evidence, because I'm not your counsel in your matters. I'm only a lecturer for the day. I hope you understand this. We have already discussed about this. Now, there is one thing you have to understand. If you are not able to make this all electronic evidence and you want to engage a cyber expert, that cyber expert, whosoever you go and contact with, you have to give an authority letter to that person, because without authority or without that power of attorney, whatever documents he creates will have no standing in the court of law. This is the only thing you have to understand. Now, I get many questions like this, that if I am not a cyber expert, can I appoint another cyber expert advocate who can come and depose in the court? Sorry, he can't. It is not his job. For a person of cyber expert, he has to be registered somewhere with the government as a cyber expert. Somewhere he has to be acknowledged as a cyber expert. Somewhere his education, knowledge, and industry should be cyber expert. You cannot hire another advocate who has done all your 65B3 work, and he comes to the court and says, yes, I was given the authority and I have prepared everything. Sorry, we are barred by professional ethics. Do not engage in such practices. It is not our job. You can take an assistance of an co-advocate, but you cannot engage him as a cyber expert. Me, for example, I am a cyber legal expert. I am not a cyber expert whatsoever. Next slide, please. Now, these are some of the news which are only to enlighten you what actually is going around in the India with respect to electronic evidence. The first is wife entitled to husband's CDR location data if she suspects affair. Delhi High Court has recently passed this judgment. This judgment is based upon derivative evidence. Initially, there are several contradictory judgments of Allahabad High Court where the husband has tried to take out the location details of the wife and the court has denied. But this judgment differs from that judgment because the wife has stated, say for an example, she says that on 15th of April, I have seen my husband go into that hotel, and she is requesting to the court to direct the investigating officer to bring on record his location details of 15th of April to prove her case, whether technically he was there or not. So to that extent, the court has allowed. The court cannot pass a blanket order saying that the wife is demanding her husband is having affair, take out all the details where he was going. Sorry, that is not permissible. If you specifically doubt and you want to prove that on this XYZ date he was there, in order to corroborate, in order to provide a assisting or then advocating proof, you can call the records, and that will ultimately be a derivative piece of evidence. That is why I explained to you the terms of derivative evidence. Second is not required to play video evidence before witness or transcribe its contents for admissibility. What was happening is, after several of the lectures on admissibility of electronic evidence, several of the lecturers maybe gave a message to the advocates that once a Panchanama video comes before the court has to play the Panchanama video and each and everything. Now we have sit in the car. Now we are going from the BT Kavde road. Now we have taken a left to the NIBM road. Now we have stopped there. All this is not necessary. You can play the video. You can ask the Pancha whether this is the video that you have shot. Yes. Have you adduced a transcript to show the way? Yes. Sufficient. Do not waste the time of the court. Initially, what was happening is advocates had started questioning each and every move which was there in the video. So Supreme Court has come down heavily on that. Court has stated if there is a video, play the video, Sufficient. Show it to the witness. Witness accepts it. Yes, this is the same video which was shot. Sufficient. Now ask the subsequent questions. You do not have to play the entire 1 or 2 hour long video. That is the simple thing. Now, no need of transcript. The Supreme Court in the same case has also stated that just in case you have played the video and the transcript is not produced. Now you have played the video, but transcript is not produced. Transcript is not compulsory. Now understand once again, this is regarding criminal trial. I cannot guide you that this same applies to family matters. So it's always better that you make a transcript of whatever you are submitting to the court. Now, secretly recorded spousal conversations admissible, derivative evidence, which I have already understood. Non-filing of certificate at relevant stage is curable defect. Now, most of you are worried that now I have submitted the mobile phone or I have submitted the electronic data, but I could not submit the 63 certificate. Now, what is to be done? You can submit the 63 certificate on a later stage. That is a curable defect. Now, if you are appearing on the other side, that cross-examination question, you have the power. Why did you not submit in time? That is how you play with the cross-examination questions is your freedom. There is no straitjacket formula of how a cross-examination can be conducted. So it is your own knowledge that you can take a risk upon. Divorce case, wife's WhatsApp chats can be valid evidence about her extramarital affair even when obtained by derivative means. That word of the news is missing. So basically, in short, derivative evidence is admissible. In the present case, the husband had installed some spy app in the wife's mobile phone. He used to check all those records on his laptop. He took the print off of all the records. He submitted in the court. The wife, instead of denying that all this chat belongs to her, said that he was having a snooping on me. He was invading my privacy. Now, if the wife is going with such an argument, then God bless her. God bless her advocate. Supreme Court has already said derivative evidence is admissible. Husband case came to be admitted. If the wife would have taken a stance that these chats do not belong to me, then that would have been a different judgment. So this is only in aspect of giving you a brief idea of what is going around in India with respect to the electronic evidences. Now, the next slide is only merely a quote. A wise man proportions his belief to the evidence. Now, this is once again going back to the story I told you about Joking and Susanna. If the word of the mouth was to be believed, there was no need of a trial. That is why evidence becomes extremely important. Now, we would be taking some questions. If you have any, you can ask the questions. Ruchi ma'am will take the questions. I'll be more than happy to enlighten you.
Definitely, sir. We have got few questions in the written form. First, we'll walk through those and then we'll have the questions
Yes,
for
yes, yes.
who have raised their hands. So the first
Yes.
question is about wills. Can a video recording be considered as a will, as an electronic evidence without doing physical document of the will and without registration? Will it be executed
Yes.
after the death of a person?
Yes, it can be executed. You can file for the probate. You can always approach the civil court. You can produce before the court that this is the video recording of the person who was making the will. But then ultimately, the most important condition that the opposite party is going to challenge you is upon whether that person was sane at the time of giving such a statement, because that is to be backed by evidence of a medical officer. It should not happen that that video was taken under pressure or under threat or under any kind of a fraud. So that ultimately opens up the door for cross-examination. But as long as you are on the aspect of admissibility of that video, yes, it is admissible before the court.
Two. Can printouts of WhatsApp chat be submitted without the 63 certificate? One of my opposite advocate has furnished printed forms of screenshots of WhatsApp chat. How can I challenge it? What should I do? My experience.
Those chats will not be exhibited in first place. If the court proceeds for exhibiting those documents, you can always raise an objection that these chats are not, assisted by a 63 certificate, and you can raise your objection in written form. Never go for anything oral. So make submissions on a written form that you have raised an objection that as on today, till date, no 63 certificate has been adduced on the record along with the screenshots, and those screenshots any which ways won't be exhibited. So don't worry about that. And if your matter is in Pune Family Court, then all the judges are brilliant to that effect. Don't worry, that won't be exhibited.
Okay. And there's this other question. 1 minute, I just lost my connection. Can we get PPT or any
Sorry. Ruchi ma'am, your voice is
breaking?
Yeah.
Am I audible now, sir?
Yeah. Now you are audible.
Yes. So there are attendees who would like to get your presentation, sir, and PDFs. Would it be
That's
possible for
fine.
you
That's
to?
fine.
Yes. All
Yeah,
right.
that's fine. That's fine. It's okay. I've always done good for the community of advocates. Don't worry. I won't retain that PPT with me.
Thank you so much. And of course, the recordings would be available on YouTube soon. So we have our channel. We'll be uploading it soon. Yes.
Yeah.
The next one is this electronic evidence rule applicable in tribunals? Example, NGT as well, National Green
Yeah,
Tribunal.
everywhere. Simple.
Okay, Nitin. Again, without witness in the video recording, does it require 65p certificate? What does he mean? Nitin sir, if you
What
are, yeah, I think it's an income.